And now we are turning to our last two countries, Poland and Hungary. And I'm going to hand over again, not just the microphone, because my esteemed colleagues Marietta and Esther are sitting right next to the other side of the table. So ladies, what's on in Hungary?
So, welcome everybody, all participants who join to our Hungarian and Polish session. And first of all, let's see a general overview. But before that, just some words about us. My name is Marietta Molnár. I'm a senior associate at Employment Practice Group at Wolf Theiss, Budapest. And next to me, sitting my nice colleague.
Hi everyone, my name is Eszter Bohati, and also would like to ask every participant to take up the hands if you don't hear us. If there are no hands, then we are going to continue our short session.
Okay, so let's get back and take a look on the general rules. In Hungary, the general rule is the place of work is a fixed place of work that should be agreed in the employment agreement. And another atypical form is teleworking, where the employee is permanently working remote from the office or the employer's other facilities. And between these two types of working form, there is a special alternative as home office, called home office, which means temporary remote working. And nowadays there is no specific rules in Hungary for this type of working. So
what are the main differences, just in a few words again, to provide you a short summary? Fixed place of work means the general rule, while the atypical employment agreement contains the place of work when we are talking about teleworking, as for example the employee's home, while home office has no legal background currently in Hungary. And now we are going to talk about firstly the options which are already regulated in the Hungarian Labour Code. The first is the teleworking, as we are not going to mention the general rule. Teleworking is about, let's say, another type of employment agreement where the parties agree that the employee is not going to work from the office of the employer as it's usual, but from another place. Also, there is some additional information obligation on the employer's side in that case, and it's also a requirement in this case that the product of the employee's work is transferred to the employer by electronic means.
yes,
And I think that we can already switch to the home office, as teleworking is already known by the Hungarian employers.
known and fortunately regulated. That's the point, because during the pandemic situation, that was the only one form of working which is different from the office work and regulated by Hungarian Labour Code. And that's why during this outbreak, employers and employees tended to apply similar constructions to teleworking.
Now we can switch to the next slide.
Yes, home office, as we called in this slide as a gray zone, and this mentioned, it's a little bit misunderstanding, but it's an old new question, because home office is not a new issue in employment practice, and used for a lot of working positions, but not a general solution.
Let's say that this is the white raven of the Hungarian labor law, because everybody knows this solution as well. However, due to the lack of the legal background, the parties had to establish the background, for example, in employers' internal policies and so on. So there are no core rules included in the Hungarian employment law, but these are formed and established by the parties, mainly by the employer. Also, during this spring and the summer, the Hungarian government allowed the employers to unilaterally order home office. However, this solution is not available as of the end of this summer, so this is already clear that the legal background had to be stated and had to be made within a framework by the Hungarian government.
Yes, and this is why the new rules are highly required and expected as well by both employees and employers.
You can see this table. We try to summarize the main rules. We already talked about teleworking. We already talked about home office without rules. I mean, the place where nobody knows where to go. And also there are summarized the expected new legal framework. We have a few information in this respect. Nevertheless, the new bill, I mean the act related to the amendment of the Hungarian Labour Code, is not known yet. So we are a bit blind, as everybody else in Hungary in this respect nowadays. But we highlighted the most important questions and information related to the new expected amendments.
Yeah, the first one is the point of the concept. The new concept is based on the parties' agreement unchanged. That means furthermore, employees and employers also have to agree on this solution.
And this is not a new thing, sorry for interrupting, but this is not a new thing, as prior to these expectations, also the home office based on the parties' agreement. I mean, the employee went to the employer, asked for a day or a few days at home, and that's all. And this is going to be stipulated in the labor code, expected.
Yeah, and another hot issue in relation to home office, as I think, but you can confirm or deny it, the compensation of costs incurring with home office work, especially the utility fees and the internet connection fees, and based on the high-level information, there will be a balanced solution for this, a monthly flat contribution.
Yeah, everybody knows that these are these are hot topics every day, because what if, for example, the rental fee is increased by the lessor for the employee? Is the employer obliged to compensate the employee for these costs or not? And we expect to have, within this new legal regulation framework, at least one clause that's going to clarify the background of the situation, as everybody can feel that there is some compensation question that must be solved by the legislator.
Yes, and there are a lot of open questions related to home office. For example, the working schedule and work safety rules, who is obliged for compliance of these rules and so on. But these are not decided yet. But in our opinion, supposedly there will be a similar solution to teleworking.
Yeah, and that's just to provide a bit help for the employers how to decide which way could be chosen by them. We would like to provide you with some questions. The first question to be answered is whether the remote work would be a temporary solution. We already said that teleworking is a well-known solution for Hungarian employers. However, if they are not providing services, for example, in IT sector or someone like that, then the temporary nature could be questionable. I mean, the permanent nature could be questionable. Thus, the temporary solution way could be an answer. If that's the case, then the answer is yes. The next question, whether there is a consent, a mutual consent between the parties, I mean the employer and the employee. If the employee is open to agree, I mean to change the place of work, because that means that clearly, then the parties can agree in the home office, the application of the home office. However, if there is no consent between the parties, the employer, which is, I think that it's not known by the Hungarian employer has 45 days per calendar year, and in that case, the employer unilaterally orders the employee to work from another place than the usual place of work, included in the employment agreement.
Yeah, and it should be noted, because of the current pandemic situation in spring and summer, this solution was generally used by the employers, and therefore this quote already used. Most of the employers in Hungary. So, at the end of our presentation, we would like to speak about a little bit what if home office doesn't work in practice, because it's a good question.
Yeah, because the employer, must be prepared for the case when there is no agreement between the parties. I mean, the employee did not agree to work from another place than, for example, the employer's office. What can we do in that case? Well, it depends as well, and it must be assessed on a case-by-case basis, even if the home office is an available mean to be granted to the employee. If it's granted, but there is no agreement between the parties, the employer can decide to order the employee to continue work from the office, or allow the employee to be at home, but in that case the employer has some payment obligation as well. Also, it must be assessed when deciding about the home office, whether the employee would be able to perform his or her work from home. For example, there are some living circumstances that wouldn't enable the employee to, effectively perform his or her work, and so on. So there are a lot of questions to be answered prior to deciding about the home office. And what we also wanted to mention, and I think that this is also an old new instruction possibility on the employer's side, is the working time frame that could be also introduced by the employer.
Yes, that's true. But there are some positions where home office is not an option based on the nature of work. For example, factory workers, where there is no physical possibility to work from home.
That would be a bit difficult to move the machines to the home.
Yes.
So.
Yes, exactly.
So that's all. We wanted to summarize in a few words the Hungarian legal background now and the expected new changes. And if you have any questions, then please send us.
Well, Esther, Marietta, thank you for that. Before we move into the questions, we are eager to hear Poland as well. So, Agnieszka, the microphone is yours. Please go ahead.
Thank you. Hello from Warsaw. My name is Agnieszka Nowak-Blaszczak, and I work in the employment practice group in the Warsaw Wolf Theiss office. I would like to give you a short presentation and focus on the legal framework of remote work in Poland, as well as give you some tips how to solve problems created by remote work. At the end, I will speak also about planned new regulations on remote work, because the Polish Labour Code will be amended in this respect. Before the pandemic, only telework was regulated by statutory provisions. The Polish Labour Code defines telework as work that may be performed regularly outside the permanent workplace, which must be stipulated in the employment contract, and this work is performed using electronic means of communication. But occasional remote work outside the workplace, for example, occasional home office, does not fulfill the statutory requirements of telework. Such type of remote work is still not regulated by the Labour Code. Of course, it was already used even before the pandemic. It was used based either on employers' internal policies, regulations, or based on an agreement which was concluded with the concerned employee. After the COVID-19 outbreak, the so-called anti-crisis shield, this is a bill which is aimed at combating the outbreak. The anti-crisis shield has entitled employers to instruct employees to perform remote work for a fixed period of time, but only for the purpose to counteract the spread of COVID-19. That means that employers are entitled but not obliged to order employees to work remotely. There is no need to modify the employment contract, and also the consent of the employee does not need to be obtained. Employees are required to follow the employer's instruction as long as these instructions are compliant with the law and the employment contract. The anti-crisis shield does not specify the form of the employee's instruction. Therefore, remote work can be assigned in any form, but of course it is in the interest of both parties, the employer and the employee, that the instruction on remote work is included, for example, in an official email or in a letter. Initially, these regulations of the anti-crisis shield on remote work were supposed to be applicable only for 180 days until the beginning of September. However, later amendments to the anti-crisis shield extended the period of application, and these provisions will apply for the entire period of the epidemic state caused by COVID-19, as well as during the first 3 months after its cancellation. Employers can instruct employees to switch to remote work, provided that the employees have the skills as well as the technical and housing capabilities to perform such work. And of course, the agreed type of work, which is stipulated in the employment contract, can be performed remotely. And the instruction to work remotely can be withdrawn by the employer at any time. It means even from day to day. Therefore, the needs of the business can be taken into account. It is the employer's responsibility to provide the employees with the required equipment as well as the materials, for example, printers, software or laptop, as well as the logistical support. Employees can also use their private equipment, but only under the condition that the protection of confidential and legally protected information is ensured. There are, of course, many positives in remote work for employers, such as the reduction of office space or the reduction of office costs. But there are also negatives. It can, for example, happen that employees who work remotely are not very efficient or productive, or employers have a limited control over how employees truly are spending their time. In such case, in accordance with the anti-crisis shield, the employer may require the employees to keep records of activities which they perform. Such record can, in particular, include date and time of the performance of activities, as well as a description of such activities. The employer is free to decide about the form and the frequency of these activities records. This is, of course, only an option. Employers have no obligation to require employees to keep such records. Also, adopting clear rules on remote work can be helpful from the perspective of the employees. It can give employees comfort and clarity on what is expected from them. the rules for remote work should in particular clarify how remote work is ordered by the employer, how commencing and end of work should be confirmed, how working time should be recorded, or also the ways of communication with managers, with superiors. When developing such rules for remote work, it is always advisable to discuss and talk with the employees in order to develop a set of rules which will allow for effective performance of duties and the verification of their achievement. At the end, I would like to talk about the unavoidable amendments of the Polish Labour Code, because currently a draft amendment to the Polish Labour Code is being discussed. The draft amendment is in an early stage and it is still not accessible for the public. The draft was forwarded for consultation to social partners, the representative of employers and trade unions, but the press informs about the draft, the consultation discussions. The idea of this amendment is to replace the existing provisions on telework with provisions on remote work in order to introduce more flexible work arrangements, which will allow also the occasional performance of work outside the permanent workplace, because it's right now, according to the Labour Code, it's not regulated. As proposed in the amendment, the general terms and conditions of remote work will be determined in an agreement concluded at the company level between the employer and the trade union, of course, if a trade union operates at the company. If an agreement cannot be reached within a specified period of time, or no trade union operates at the company, these general rules, terms and conditions of remote work will be set out in bylaws adopted by the employer. However, these terms and conditions can also be defined individually or more precisely in an agreement which is concluded by the employer and the concerned employee who will work remotely. As a rule, the employer will not be entitled to instruct the employees to work remotely. Remote work instruction can be given only under special circumstances. It will be an exception. For example, in the case of a pandemic, or if it will be necessary. Furthermore, what is also interesting, it is being discussed whether to grant some employees the right to work remotely, in particular, employees who are parents of young children or parents of children with disabilities, in order to allow them to achieve a work-life balance. The employer would be able to refuse the right to work remotely only due to objective reasons. According to the draft, the employers will be obliged to communicate such reasons within 3 days. The rules regarding the reimbursement of costs to remote work are still not decided. A payment of a lump sum was considered, but representatives of the employers are criticizing and objecting it. Another possibility, which is also discussed, is to regulate the reimbursement of costs in an individual agreement with the employees, taking into account all circumstances. Also under discussion is the regulation regarding the employer's responsibility for occupational health and safety of remote work. It is proposed that the employees working at home will be responsible for the proper organization of the workplace. Before commencing the performance of remote work, employees will declare that the workplace provides safe conditions to perform their tasks and duties. In the negotiations, employers have already insisted on the limitation of their liability to accidents at work related to the equipment and the materials which have been provided by them. The final wording of the draft bill is still under discussion and it's not known. However, it would be advisable to keep an eye on the outcome of these negotiations and discussions and the final version of the new provisions on remote work, in order to be aware how remote work will be very soon, hopefully, regulated in Poland. Thank you, and this is all from my side.
Agnieszka, thank you for that. it seems that we are in the same situation in respect of Poland and Hungary. We are eagerly waiting a new legislation. And just a couple of questions arrived in connection with the presentation of Marietta and Eszter, so I turn to them in connection with the Hungarian situation. The first question is that can we allow certain flexibility of working time during home office? For example, with employees who have kids on homeschooling, therefore their attention is less concentrated during the day, and they might work early in the morning or late evening instead.
Yeah, it's a good question, and generally our answer is the employee has to work at home, also as usual in the office, and according to the working time ordered by the employers. But there is a possibility to inform the personal circumstances of the employees to the employer, and the employer has right to allow some flexibilities in daily working time. For example, divided working time, or for example, flexible working time, where the employee can decide on the scheduling of his or her daily working time.
Excellent. One more question, as the final one. How can the employer handle overtimes performed in home office, not only particularly during COVID, but generally? Can the company refuse to accept the reported overtimes, considering the fact that the employer's ability to scrutinize the employee's performance is rather limited?
Well, this is always an open question for the employers, but what we can tell you as employers is that first, overtime must be always ordered, and the employee must be instructed by the employer or the direct supervisor of him or her to perform overtime work. That means that without such an instruction, that could be also implemented in an internal policy by the employer to clarify the background. Without such an instruction, overtime is not an overtime work. That would be questioned by the employer. Also, the employer has a continuous obligation to keep records of working time, and unless there is any deviation from that, then the working time of the employee is the working time which is included in the scheduled working time registration. Also, if you receive some information from the employee that he performed additional working hours, then that information could be compared with the one that you receive from, for example, as I mentioned, the direct supervisor. And if there has not been any instruction, that's another question whether the employer accepts that from the employee's side, or says to him or her that this is questionable and it must be further assessed, and at the end accepts that or not.
Well, thank you very much for the answer. And the last part is mine. A great and big thank you for all the participants, my esteemed colleagues, and everyone on the other side of the line who actually asked questions and hopefully gained some new insights on what's going on in the region. So thank you all the participants. I'm pretty sure, or I hope, that we will see each other soon in person. And as a final word, it's a pretty long autumn is coming, and a long winter, and with lots of changes. New labor code in Croatia, various changes from Poland to Czech Republic and Slovakia as well. So stay tuned. We are here for you, and thank you for your time and attention.